every Tuesday from 5 p.m. Central Time to 6 p.m. Central Time. We do bring in immigration updates and we do take live questions. And along with me is my business partner, Rebecca Chen. Rebecca, what do we have today to discuss?
Yeah, well, with the election quickly approaching, we have been considering the immigration implications of a potential second Trump administration. And one big concern is what a second Trump administration might do regarding H-4 EAD. So we'll talk about, can Trump end the H-4 EAD program next year if he is reelected? We'll also discuss STEM OPT, what employment is allowed. Can you work for multiple employers while you're on your 2-year STEM OPT? And if so, what do you have to do in order to be authorized to work for more than one company? We'll also talk about job portability when your I-485 is pending for the 180 days after the 180-day period. How do you change employers? What are the requirements? What do you need to do? What does your new employer need to do? And we'll also discuss the EB-5 option. Is it the fastest way to a green card? We've been discussing it more on this channel this year. And yeah, we'll talk about how it may or may not be the fastest way to a green card.
Coming to the H-4 EAD, though, it's not passed by the Parliament, or what we call Congress in the United States. It's a regulation that's published by the administration. The then Obama administration published a regulation based on which they have given the H-4 EAD. And of course, it stood to the test in the federal court a couple of times when they challenged it. Though, however, when a president can issue the H-4 EAD, another president can cancel it too, because it's not something that he has to go to the Congress to get it done. What are the probabilities? I mean, is he eyeing on H-4 EAD, or is only looking more into illegal people having employment authorization? And if he wants to intend to cancel, as soon as it comes in, can he cancel? Does it take some time for him to cancel?
Yeah, of course, it's hard to say. We do know that, of course, in the first Trump administration, they did try to eliminate the H-4 EAD. So we wouldn't be surprised if a second Trump administration tried to do the same thing. If they did, would it happen within the first year of the administration? Most likely not. First of all, among the ex-president's immigration priorities, of course, his focus, or at least in his rhetoric, his focus has always been on illegal immigration and securing the border. So we would anticipate that his first actions, if he were to be reelected regarding immigration, would probably be along those lines, not necessarily zeroing in on the H-4 EAD as one of his first policy priorities. But the administration has tried to get rid of it in the past. And so if they do try to get rid of it again, we would anticipate there would be lawsuits like there was the first time, that it would have to make its way through the federal courts like it did last time. The first time there were certain things that led the administration's attempts to get rid of H-4 EAD to fail. They may have prepared better, with a second attempt. So it is, that's the main vulnerability of the H-4 EAD. When it's based on a regulation, it can change based on the incoming president. But if it is targeted, most likely, I would be surprised if it would, be within the first year, within 2025, just because of how slow things move through the courts, and we expect his priorities would be elsewhere first. Having said that, though, we still would encourage people who are on an H-4 EAD, if you're working for a company and they are willing to sponsor you in the H-1B lottery, if you have not been counted in the cap before, it's still a safe practice to try to get counted against the cap so that you have something to fall back on in case the H-4 EAD does get eliminated at some point. You can move into H-1B status as a backup.
So you're suggesting that, if Trump comes in, there is a chance that the H-4 EAD, but as a precaution for those people who are in H-4 EAD, try to get an H1B, be counted toward the H1B number, even though you may want to use the H4 EAD afterwards, so that just in case if something happens to the H4 EAD, you can always move back to H1B at any point of time without any hesitation. Because once you're being counted, you were on H1B for, let's say, 1 week or 10 days you worked on H1B, you can always get back to H1B at any point of time. Now, of course, there is high demand for some of the high intellect people that are on student visa, especially in the artificial intelligence and security and certain other issues. Can they, if they get a job, let's say, for example, I'm working for Deloitte company, and then let's say I get another job with another ABC Consulting Inc. While I'm on the STEM OPT, everybody knows on H1B, people can work for multiple companies at the same time. They can work for company A, they can work for company B. They don't need to inform company A they are working for company B, as far as the immigration laws are concerned. So company B need to know that they're working for company A, and they can file a concurrently filed H1B. What if I'm a STEM OPT? That means I completed my OPT. I'm the STEM extension right now. For the STEM extension, as you know, Rebecca, everybody knows that they have to file a 983 form with a DSO. And based on that, they will issue an I-20. Based on that, they will file the I-765, which everybody knows how to do it. But what if I get another job and I want to do 2 jobs on STEM OPT? Can I do it? And if I can do it, what is the process for it?
Yeah, so you can work for multiple employers while you're on STEM OPT. However, you do need to notify your school's DSO and get a new I-20 endorsed with the second employer's name and the authorized start date and end date of that employment. The DSO may ask you to get a 983 filled out by this new employer as well. You don't need to file anything additional regarding, with an I-765 or anything like that. If you already have the approved 2-year EAD card, you don't need to file anything additional with USCIS in order to work for a second employer, but you do need to inform your school so that they can evaluate and ensure that it is employment that is in line with the STEM OPT requirements and issue you an I-20 that authorizes you to work for that second employer.
It's that simple, Rebecca. Okay. Yeah, a lot of people are mistakenly believing that they cannot work for 2 employers. And we are very surprised when we release a video of the H1B that people can work. And we didn't know that. A lot of people didn't know that they can work for 2 companies. And on STEM extension also, you can work for 2 companies. Now, there are a lot of people who filed for H-4 applications in 2020 to 2022, Rebecca, that are still pending. And then they have that EAD. Some of them are losing the jobs and finding new jobs, and some of them wanting to move to a better job. In your practice, though, have you seen any risk involved when the person is moving from company A to company B? He's in adjustment of status, got an EAD. It's been more than 180 days that they filed a 483 application. They have an I-140 approval. Do you see any risk involved in it?
No, very little. Moving to a new employer when your I-485 has been pending for at least 180 days, it's very simple, especially if you have the EAD. By then, the new employer doesn't even need to file anything on your behalf with USCIS. With the EAD, you can just join the new employer. A lot of people are aware of the I-485J supplement, and so they asked, do I need to have the new employer file that J supplement on my behalf before I join them? The answer is no. So we used to think that J supplement or an employer letter needed to be filed by the new company at the time you were joining them. In the past few years, it's been clear that USCIS has not been requiring that J supplement to be filed proactively by you or the company. All that you really need to ensure is that the new company is willing to fill out and sign the J supplement if you get a request for evidence from USCIS asking for it, or if you're called in for an in-person interview related to the I-485, you will need to bring in that J supplement attesting to your current employment, your current job offer with the company. But that's about it. And then as far as the employment itself, it just needs to be same or similar to the employment described in your approved I-140 petition. And USCIS has been pretty flexible in interpreting same or similar, as long as it is, in the same industry that you've been working in, using the same credentials, the same education background, the same qualifications that you've used for your I-140 petition, it will be considered same or similar largely by USCIS.
So there is no requirement, Rebecca. Now, in the H1B, when I'm working for company A and I need to move to company B, you told everybody that they have to file the H1B transfer before they move. And you told the same thing, that if I am moving from place A to place B, the amendment need to be filed before I move. And now when it comes to the 485J, in the final green card, you're telling I don't need it?
That's right. Yeah, that's one of the benefits of being an adjustment of status applicant and no longer needing to rely on the H-1B visa with all its, requirements about LCA and, amendments for work location and all of that. Yeah, the new employment can be anywhere in the U.S. They don't need to be offering you a certain salary level, although if it's same or similar, most likely, the wage is going to be comparable to some extent. The only requirements are that it's same or similar and that it be a full-time job that you're being offered.
Rebecca, let's just pursue it. EB-5. Nowadays, people have a lot more money with a lot more salaries, and though we lawyers don't get that much, but these people are getting good amount of salaries. Now, these people want to move to EB-5. Of course, the priority date for certain EB-5 categories are still current. They're expected to be current, but they may go backlog for Indian nationals, and which we already seen that for Chinese nationals, they're already backlogged. How long does it take for them to get the green card? Is it possible that is it normal that people get a green card in 1 year? Or is those people who are telling are probably faking it?
Yeah, so there may be some misunderstanding about what exactly you can get through the EB-5 process and when. So for the final green card, the unconditional green card, the permanent resident card, it's going to be more a process of about 7 years, since there is the requirement of the removal of the conditions. The green card that you receive initially is a conditional green card that you will need to apply to remove the conditions of, where the government is going to look into the investment to ensure it is still a qualifying investment. So to get that final permanent green card is probably at least a 7-year process. However, you can potentially get the EAD pretty quickly through the EB-5 process if you qualify and can file the I-485 in the EB-5 category, especially because for Indian nationals, certain categories are still current right now. You can potentially get the EAD pretty quickly, within a year or less, through that process.
Let's go to questions, Rebecca. I see the questions from Money, who's asking the question, can the H-1B person travel outside of USA for a vacation while the spouse stays on H-4 visa in United States? On a vacation, absolutely you can. Can you move back to your home country and started working there? And can your spouse stay in United States? No. But if you're just taking a vacation, let's say 1 or 2 months, I don't see a problem in the H-4 staying in United States.
Chaitanya has a question for Canadian citizens who receive an H-1B approval notice for consular processing. Do they need to go to the consulate for visa stamping before they can enter the U.S. in H-1B status? No. So if you have a Canadian passport, you are considered visa exempt, which means you still need the H-1B approval, but you do not need to go to the consulate and get the H-1B visa stamped in your passport the way that Indian nationals or other countries' nationals do. So in order to enter the U.S., you just travel with your Canadian passport, your I-797B notice of action, and you will be admitted in H-1B status.
Family from YouTube has this question, Family G. The person is currently on H-4 EAD. The question is that if the H-1B change of status has been applied, what happens to the H-4 EAD? Is it cancelled when I move to H-1B? It's not cancelled. We call it as the dormant H-4 and H-4 EAD. It doesn't get cancelled. You can activate it by two ways. You can file the H4 plus EAD again, or you can just go to Mexico or to India and come back. Hey, here's my H4, here's my H4 EAD. They become active again. There are some people, hey, I want to move back to H4 EAD. I don't want this H1B. I want to work for multiple employers. I just want to sit at home. I don't want to be bounded by the H1B LC regulations. So can they just go to Mexico and come back? Yeah, they can activate it. It doesn't get canceled. It becomes dormant. That's what we call it in our legal language.
Charan has a passport that's expiring in March, and he is going for visa stamping this December. He wants to know, does he need to get his passport renewed before his visa appointment, or is it okay to do it afterwards? If you are able to renew your passport before going for visa stamping, that would be best. It's not absolutely necessary, so the consulate can still place a visa in your passport even if your passport is expiring within 6 months. It's within their discretion. For the most part, they will still place a visa in your passport if it's not expiring, within 2 weeks or so, or something like that. The main issue with not renewing your passport first is when you're traveling back into the US, your I-94 will be cut off based on your passport expiration date, even if your H1B is still valid for another 2 years. CBP's policy and practice is to issue the I-94 only as long as your passport is valid. So you'll either have to travel again after getting the new passport or get your company to file an H-1B extension for you. So in order to avoid that extra step, if you can get the passport renewed now, we would recommend it.
Arindam has this question. He's an EB2. He got evaluated in EB1A. Most probably seems that he's going to file the EB1A. His question is, his daughter is 19 years old. If she is getting some internship offers, which she cannot do it in H4, and she's contemplating moving into F1, his question is that if the EB1A gets approved, if the child is an F1, can the child still be included in the 485 application? The simple one-line answer is yes. Your daughter can be included in the 485 application, even though your daughter is an F1, even though your daughter is not an H4. The only requirement is under 21 years age. That is the main requirement which he meets. So you're perfectly fine, and then move your daughter to F1, and then you can always convert back into H1B. I don't see that as a problem. Question from Maita Rana has this. You described about an I-485 application. People can move out of the job. They don't need to file the I-485J supplement. Only when there is an interview or when there's an RFE, you need to file the I-485J. Is that true in case if the person is moving out of the job within 180 days? No. We strongly recommend if you don't move out of the job within 180 days after you file the 485. That's number one. And if you have to, you've been forced to, I would strongly recommend it to consult an immigration lawyer to have a one-on-one advice so that you can evaluate what is the best option. But as my advice would be simply don't leave the job. And if you have to, consult a lawyer. Now, whenever you consult a lawyer, it's not mean that it's a good thing, guys. It's something because you're risking much that then we're advising you to speak with a lawyer.
Banu recently got his green card approved, so congratulations to him. He's asking when can he change jobs, and will it cause any problems going forward with his permanent residency or naturalization? You can change jobs at any time now. You're a green card holder. You're not required to remain with your I-140 petitioner for a certain amount of time. We do know that there is kind of a rumor or misunderstanding out there that you have to remain with your I-140 petitioner for 6 months after getting your green card. Otherwise, they could try to revoke your green card at the naturalization stage or something like that. That is not true. That seems to be a misconception that's put out there by attorneys that work for those companies in an effort to keep people at the company. The AC-21 rules that we were talking about earlier, they allow you to change employers even before you get your green card. You can change employers after your I-485 has been pending for 180 days, even before your green card is issued. So if the government allows you to change jobs before you even get your green card, there's no reason why you need to remain with your employer for a certain amount of time after you get your green card. So don't worry about it. You can change jobs at any time now that you are a green card holder.
Question from Vijay Mahapatra. He got an RFE for medical. His priority date is not current. It's in December 2014, December 1st, 2014. It is very possible that they can issue an RFE on the medical even if the priority date is not current. Even it may not be contemplated to be current in the near future. They can issue it. They do issue it. We see a lot of those things. Please take it very seriously and respond to the RFE. Do not neglect it.
Akil applied for an EB-1A in premium processing over a week ago and hasn't gotten a receipt notice yet, and is asking if we've been seeing similar delays in receipt notice issuance. We have seen delays in receipt notices being issued, even for premium processing cases sometimes. Yeah, so I know a few cases where we've gotten the approval of a premium processing case before we even got the receipt notice. So yeah, ever since USCIS has changed all its filing locations to lockboxes earlier this year, that seems to have slowed down some of the intake process or the receipt notice issuance. If you are concerned that the application wasn't properly filed, you can try checking your bank records for the filing fee check. If they show that the filing fee check that you mailed in has been cashed, that does mean that USCIS has received the application and it's in process. They only cash the check when an application is properly received and filed.
Vitali and other people have this question that can the administration has authority to cancel the existing already approved EAD H-4 EADs? Do they have an authority? I think so, they do. But will the administration do it? I don't think so they'll do it because it's going to be a nightmare to control the I-9 regulations for that. So it is possible for the president to cancel it, but we are not expecting it, even if the Trump comes to power.
Praveen has an H1B renewal that is pending, and his GC EAD just expired and wants to know, can he file for the renewal of his EAD while the H1B extension is pending? Yes, that's fine. Filing the EAD renewal doesn't depend on your H1B. You don't need to be in H1B status at all in order to apply for the EAD renewal. However, because you didn't apply for the EAD renewal before your current EAD expired, you don't get the auto extension of the EAD. I don't think you need it because it sounds like you're working on your H1B anyway, but just in case you were planning to go off of the H1B and work based on the EAD, it sounds like in this situation, you're not able to until you get the new EAD in hand, because the auto extension doesn't apply in your case. But you can apply for the EAD renewal. That's not a problem.
Vishwa has this question. Can the USCIS ask for missing documents when the priority date is not correct? Absolutely, they can. Absolutely, they can, and they do ask those questions.
SY is asking, so he's applying for the I-485s for him and his family. He has about 2 years left on his H-1B, and given the cost of the EAD and APs, now that the filing fees have been unbundled, it's like $260 now for each EAD, $630 for each advanced parole application. He's asking, is it worth it to apply for those or just rely on the H-1B? That'll be kind of up to you, but I think it's still worth it, definitely, to have the flexibility of the EAD, especially. The advanced parole is more expensive, and the downside of the advanced parole is it's taking longer than the EAD, at least 6 months, sometimes up to a year. And if you leave the country while it's pending, it can be denied, and you have to reapply when you come back. So you may want to, we've been talking to our clients about their travel plans, basically. If they know they have travel coming up in the next 4 or 5 months, 4 to 6 months, we told them you may want to hold off on applying for the advanced parole until you've come back from that trip, because if you apply for it now, leave on a trip on your H-1B visa, the I-131 will just get denied immediately, and then you'll have to refile it, submit another $630 when you get back. So that's the only consideration, is timing it to where you have a longer period of time in the U.S. to wait for it to get approved. But when it does get approved, it should be issued for 5 years, the EAD and the AD. So we think it is worth it to file for it eventually.
Question from Bhargav. Can you convert L1B visa? If I'm an L1B, can I convert into L1A? The answer is simply yes, you can. You absolutely can. The question with regards to the EAD extension, that if it's an AOS EAD is already approved and I have it, and now I'm filing for an extension, can I work after the extension expires? Let's say EAD extension is expiring in September 30th. You filed the EAD extension before September 30th. You got the receipt notice by September 30th. You absolutely can continue working. The limitation right now is 540 days after it expires, but it has to be an extension. It has to be filed before the current EAD expires.
Ashish is in L1 status that's going to max out in 2 years. His EB1 priority date is in 2023, so he probably won't be able to file his I-485 anytime soon, and wants to know, should he try to move to H1B in the lottery next year, or move to H4 EAD for the end of his L1A? You can kind of plan on doing both. One important thing to keep in mind, Ashish, is that even though the L1A maximum period is 7 years, if you want to move over to H1B status, you have to do so before you've used up 6 years of L1 time. Because the H1B max out is 6 years, if you stay on your L1A beyond 6 years, you won't be able to move over to H1B status, even if you have an I-140 approval. Because the H-1B rules are that, the max out is combined H and L status of 6 years. If you don't have at least 1 day left before that 6 years is reached, you can't use that to extend based on the I-140. So before, actually, you need to consider your max out date as kind of 6 years, not 7 years on the L1, in order to move over to H1B if that's what you're planning to do. If you have the H-4 EAD option, that at least is a backup. But if you're looking to move to H-1B, in case your spouse loses their job or something like that, yeah, make sure you do so before using up 6 years of L1 time.
Question with regards to H-4 EAD. While the H-4 EAD is pending, can I travel outside the country? Now, it's just an H-4 EAD only, not the H-4, just the H-4 EAD only. Absolutely not a problem. Absolutely not a problem. Tejasvi has this question that her employer is not giving an I-140 approval copy, and he or she wants to move to a company B, and they don't have the I-140 approval. Yeah, you can file a Freedom of Information, FOIA. USCIS, just type Google it. You fill out a form, it's free, it's online, it only takes 10 minutes. But for the USCIS to give you the I-140 file, it may take almost like 5 to 6 weeks. And they'll give it to you, and then based on that, you can transfer to company B. FOIA USCIS. I'll try to leave the link in the message if I can.
So Pramila is working for a multinational organization, has been sent by her company abroad to work as a manager for 1 year, and is planning to move back to the US in a managerial role to qualify for EB1C. And she's asking, do I need a new H-1B to come back to the US company to file for EB1C? Technically, you might not need to, but we would probably recommend it because for the 1 year that you are a manager in the foreign company, you need to make sure there's no confusion, nothing that can make USCIS think that you are still acting as an employee of the US company during that 1 year that you are supposed to be a manager in the foreign company. For that reason, we usually recommend not using that H1 to come into the US during that time. If you need to come in during that time, the appropriate visa would be like a B1, B2 to, come in for a limited purpose, because you can't give any indication that you're coming in as an employee of the US company during that 1 year. So it would be best probably if your company applies for a fresh H-1B for you to come back to the US as a manager.
Question from Cool Dude. Is the H-1B visa stamping within the United States still open in Washington, D.C.? The answer is no, it's not open. Hopefully so, it will. Questions coming to with regards to priority date. Somebody is saying that he's going to be at 60 years old by the time his priority date is current. Yeah, it could happen. We want to make sure that even if you go to India, your Social Security, for you to receive the Social Security benefits, you have to be, I think, so 62, 64, 65, something like that. I'm not sure, but you have to work for 10 years. Make sure you work for 10 years, even if you move outside the country, so that you can reap the benefits of the Social Security.
Prasad was working for employer A on H-1B, moved to employer B, and wants to know, can he move back to employer A if employer A has not revoked their H-1B approval for him and it's not expired? Yes, technically, if employer A didn't withdraw your H-1B when you left the company, it's unexpired, and you will be returning to the same employment terms, the same job title, salary, work location that were listed in your approved petition, then yes, you can just move back to employer A and continue working there. They don't need to file anything additional on your behalf.
What are the horror things you have learned? You've been practicing, you've been in the immigration field for a long period of time. Since your child were high school, you've been working in immigration law firms, Rebecca, and with us from 2010. Yeah, that's 14 years. 15 years. What did you notice? Because people are asking, hey, will my L1A extension will have a problem with the Trump? Will this thing have a problem with the Trump? What did you see different in the Trump administration previously? You've been there, I think so, you're not there for Clinton, but you were there for Obama for sure. And you were there for Trump and then, of course, Biden.
Mm-hmm. Yeah, I mean,
You're there for Bush too.
Yeah, I wasn't an attorney, but I was working in immigration as a legal assistant during the Bush administration. Yeah, out of all the administrations I've worked in for immigration, the Trump administration was unlike anything we have ever seen. It was sort of an all bets are off type situation. I mean, it may be hard for people to remember now, but if you were on H-1B or doing anything with immigration during those 4 years, it was just every week, all sorts of policy pronouncements that had never been done before were being announced. Just the wholesale elimination of premium processing, the elimination of the deference policy, which meant that extension applications were now being reviewed as if they were brand new applications, which meant we were sometimes getting, or frequently getting RFEs, sometimes getting denials for people who were on their third H-1B with the same company. Just the Buy American, Hire American executive policy that just was so vague, but gave everyone from USCIS officers to consular officers to CBP officers just any reason to subjectively, deny applications, deny visas, deny admission to the U.S. if they felt like it was going to protect U.S. workers somehow. The ban, the travel bans, the multiple travel bans that were announced throughout the administration that made it so difficult to apply for visas or travel. Some of it was due to COVID, some of it was not. Yeah, it was just it was bad for employers of foreign workers. It was bad for the workers themselves. I mean, yeah, it just the most stressful time that I've ever spent in immigration was those 4 years.
Short H1B approvals, RFEs,
Yes.
L1 denials, I-140 denials, premium processing suspension, H1, H4, and EAD not getting approved at the same time.
Yeah.
I mean, whatever possibly administration can do was have been done at that period of time.
Yeah, suddenly fingerprinting any I-539 applicants, even children, babies, had to go in for biometrics for any I-539 application. Just, yeah,
A question from Abraham. I have an I-140 approved with company A from 2017. I moved to India. Now employer B is bringing me back into United States on 2024. Can I use company A's I-140 approval to extend the H-1B with company B beyond 6 years? The answer is yes. Absolutely yes, not a problem. As long as you have approval of the I-140 with company A, it's not been withdrawn for 6 months after it's been approved, you can use that I-140 to extend with company B, company C, or company D. Doesn't matter. You're in good shape.
Debbie says, are there restrictions for someone who has an AOS EAD in hand and lost their job? They were in H-1B before. Do they have the 60-day grace period to find a new employer? So that is a misconception that a lot of people have because we're so used to the H-1B 60-day grace period where you can, if you're let go, you have 60 days to find a new employer. Technically, there isn't a grace period at all for having a job offer for purposes of the I-485, keeping the I-485 pending and valid. It's supposed to be supported at all times by a job offer from the time the I-485 is filed until it's approved. So a job offer doesn't necessarily mean continuous actual employment, but it does mean having a job offer in hand. So if you are anticipating that you will be laid off and you don't think you can find another, get into another job right away, there are things that you can do to secure a job offer. If you are self-employed, if your spouse is self-employed or has a company, there are ways that you can kind of maintain the job offer, but technically there isn't a grace period for that.
Post-industrial economy, he likes Trump. He says is either approval or denial. No, it's not that though. That the amount of RFEs have gone 10 times higher. Of course, the denials have gone higher. The H-1B approvals is shorter. Previously, we used to get 3 years of H-1B approval. Now also we still get 3 years H-1B approval if the person is eligible. But when the Trump was there, we're getting only 6 months or even 1 year of H-1B approval. So every time they have to come back. H-1 and H-4 and EAD doesn't get approved at the same time. Kids, 4-year-old kids have to go for biometrics for H-4 extensions. So these are the ways to torture the immigrants. We don't see any benefit in why they're, the reason why they're doing is just to only torture the immigrants, nothing else. So, of course, you have your opinion, Mr. Post-industrial economy, that, you like the Trump administration, that's fine. But we don't like it. Now, when you're saying that law firms don't like it, let me tell you one thing. We make good money in the Trump era than compared to that of the non-Trump era. The reason is that when you get the 6 months H-1B extension, then you have to file your H-1B extension every 6 months. Every 1 year we have to file H-1B extension. When you get the denial, well, people won't keep calm. We have to refile the application when they go outside the country, and then we have to get the approvals. When the premium processing is suspended, it creates a lot of problems because if there is any denial to resolve it, it becomes a nightmare for the people. The delays also cause a lot of problem. All these things are problems for our clients. At the same time, you think so that lawyers don't like it. Yes, of course, lawyers don't like it. Good lawyers don't like it. And 99% of the lawyers are good lawyers. They don't like it. But when you're going to ask us, will be financially beneficial? Yes, we're going to be financially beneficial. But we don't like it. Nobody likes it in our law firm. Most of the lawyers that I speak, they don't like it either.
Yeah, more of it is coming back to me now that I'm thinking. One of the first things that they did was basically eliminate level 1 prevailing wage jobs from H-1Bs, basically claiming that if you're working in a level 1 job that you don't qualify for an H-1B because how can it be specialized enough if you're only level 1, even though that's the definition of an entry level software developer still requires a bachelor's degree just as any other software developer. And so that was one of the first things that came into level 1. RFEs were a routine thing for several years. And then just toward the end of the Trump administration, one of the things that they tried to do, which they which was stopped by the courts, and then they didn't have enough time to try again, was basically increasing the prevailing wages of, all the prevailing wage numbers that are used for H-1Bs, that are used for the perm process, were, raised significantly, so that, it was something that was unrealistic, but also not realistic for U.S. businesses to offer or pay those wages. And they were not an accurate reflection of the market. Our clients, the employers that, work in these industries and know what the market rate is, said that those were not accurate reflections of the prevailing wages. And so that was something that they tried to do toward the tail end of the administration. And we would expect that they would probably try to do again if there is a second Trump administration.
Parki Datta from Facebook has this question that if the, give me 1 second. If the H-1B is from Dallas and if the company allows hybrid work, can I work a couple of months in Dallas and a couple of months in a different state? Yes, but you need to file an amendment before you work. Just because your company is allowing doesn't make it legal. If you LC is from Dallas, you cannot work from Oklahoma. Dallas, Oklahoma is very far. It doesn't come within the same state. So you need to file an H-1B amendment if you're contemplating working in 2 different locations.
Venkata said that with his latest transfer H-1B approval, his total H-1B duration is more than 6 years. But it doesn't sound like his perm or I-140 were filed early enough to allow for that. So if it was an error, so we have seen this from time to time where USCIS issues an H-1B approval for basically longer than the 6-year limit in error. If that is the case, and you know that they extended it in error, then you yourself should consider the end date as the correct date, the end of your 6-year limit. Calculate that out, with your attorney, determine what that is, and then you yourself treat that as your expiration date, regardless of what the I-797 approval notice says, and just plan to file the extension before that expiration date. If you need to, you can have your attorney include an explanation in the extension of why they seem to be filing it so early. But by then, hopefully your perm or I-140 will be at a stage that allows you to get the 7th year extension.
MIP TP has this question. His I-140 got denied. Can he use the same firm to file the I-140 again? Answer is absolutely you can. Once you file an I-140 application, the labor becomes alive for the next 90 years. So it doesn't expire. Since you filed an I-140, even if it's a denial, you can still use the same perm again. All we have to show it is that the perm expires in 6 months. Within that 6 months period, we filed an I-140, it got denied, you're filing again. However, you have to overcome the reason. Why was it denied before? Can we cure that thing right now? If you can cure it, absolutely you can use it.
We have a question about an EB2 NIW, even if you have a previous I-140 approval. So the benefit of an NIW application is kind of limited. If your country of birth is India and you already have an I-140 approval, the NIW may not be that much help to you in the long run, because at this point, your goal is to try to get into a category that will allow you to file the I-485 earlier. Unfortunately for the NIW, it is still in the EB2 category. So it doesn't give you, it doesn't allow you to jump ahead or file the I-485 any earlier. It just gives you an EB2 priority date. And if you already have an I-140 in the past, you have, most likely it won't help you that much. The situations where it can help, even if your country of birth is India, is if you have no I-140 at all, you're in H-1B status and are approaching your 6-year limit, and your company either won't file the perm for you or hasn't started it early enough for you to get the I-140 before you reach the year. In that case, the NIW could be beneficial to you because it is mostly for processing time purposes. The NIW doesn't require employer sponsorship, so you can file it yourself if your company won't. And if you have, a case, then it can be processed faster potentially. Even if you don't have the strongest case, there are situations where filing the NIW could potentially get you a 7th-year extension, which might give you long enough for your company to finish their perm processing before the end of that 7th year.
Can you explain the Heartland visa bill and the chances of the bill getting passed? How will it impact Indians? I haven't studied the bill. I'm sorry about it, but I will study it by the next meeting. That's number one. Number two is that the lame duck session is what we call it as. That means that the election is over, but the new Congress does not come into field. The election will be over on November 2nd week. The new Congress and the new president will come in January of 2025. So in the meantime, the old Congress functions and they do make drastic decisions because they don't have to face the elections for the next 2 years. Some of the people are outgoing people, so they do make it. So we do observe a lot of these things. We are going to come a request to you between the dates of November 2nd week and January 1st week to write letters to the congressman, draft letters to the congressman, which we are going to do it. But for now, we just want you to follow our Zoom information, give information to the other people so that when we need it, we're going to use it for them, for you guys to write letters to the USCIS so that we can get some of the benefits the other country people are receiving, but what Indian nationals are not receiving.
Jagadish asked, what is the difference between the validity date shown on the advanced parole stamp when you come in at the port of entry, which is only for 1 year, and the validity date shown on the approval document, which is for 5 years? That's a good question and something that people have sometimes gotten confused on and can be dangerous if you don't understand the dates. For the most part, on the advanced parole, the date that is important is the printed end date that is on the document that you receive from USCIS. So when it's first approved and you receive it either as the I-512 sheet, the page, or as a combo card, the end date that is printed on the combo card or that document is the validity period of that advanced parole. You can use that to travel in and out of the US as long as you are coming into the US before that printed end date. That's the important date that you have to pay attention to. When you do come in, especially if you have that one-page I-512L document, CBP officers may stamp that page and then handwrite a date on there that is 1 year from your date of entry. For the most part, you can ignore that completely. That's also the case with the I-94 record online. If you go online and check your I-94 after coming in on advanced parole, it will have an admit date of 1 year from your date of entry. That is mostly a placeholder. When you come in on advanced parole based on a pending I-485, you don't have an actual solid, concrete end date when your authorization to be in the US ends, because your authorization to be in the US depends on your I-485 being pending. The CBP officer doesn't know how long that's going to take. If your I-485 takes another 10 years to get approved, you're authorized to be in the US for those 10 years, but they can't predict that date. So just as a placeholder, they just write 1 year from the date of entry, but it is essentially meaningless, that handwritten date by the CBP officer. It doesn't mean you have to leave the country before that 1 year end date. And it also doesn't extend the validity of an advanced parole document. So we've had some people make that mistake before. They think that handwritten date extends the validity of the advanced parole. That is not the case. For the most part, just ignore whatever the CBP officer wrote. Ignore the I-94 when you are coming in on advanced parole. Those dates don't really mean anything. The validity date is the one on the printed document from when it was issued.
Question from Venkatramana Kumar from YouTube. Can you file a H1B extension and H4 EAD in premium processing even though H4 has more than 2 years validity? You're only saying H4 has more than 2 years validity. If the H1B extension has more than 2 years validity though, you cannot file an extension unless it's been filed as an amendment-based extension. However, when a H4 plus EAD has been approved for 2 years, can you still apply for the extension along with the H1B? Absolutely not a problem. Absolutely never been a problem. Even if it's more than 2 years valid, you can still file it. Prasad from Facebook has this question. He's been working for company A, and then company B filed the H1B, moved to company B. Can he move back to company A? They haven't withdrawn the H1B. Can he still move back, or does company A need to refile the H1B application? Assuming that after you file the H1B with company B, you never left the country, and the company A, as what you said, was that never withdrawn the H1B, you can go back to employer A. Absolutely no extra filings need to be done with USCIS.
Ahmed seems to have an I-485 based on an approved NIW and is asking, with his EAD, can he work in a parallel second job outside of his field with the EAD? Yes, that's fine. So that is one of the benefits also of the EAD based on a pending I-485. You do have to have one full-time job that is in line with your approved I-140. As long as you are doing that, then you can have secondary jobs that are unrelated to your I-140, which can be, anything. It can be starting your own business. It can be driving an Uber. It can be basically anything. It can be 1099 or W-2. It's very flexible, that second job on EAD.
What if you apply NIW while on F1? You can. If you're Indian national, can you apply the NIW on F1? Absolutely. You're making a ground at a later date. You want to convert it to EB1A. I mean, you can test the ground with national interest waiver and then probably go expand it to EB1. And you can move the priority date of EB2 to EB1, which you already know. So sometimes it's very advantageous to file EB1 way in advance. EB2 national NIW way in advance.
Sue's advanced parole has been pending for 8 months and wants to know if we have any idea on when it will be approved. It's hard to say. For some reason, the EADs have been getting approved pretty quickly. Advanced paroles can, like we said, take much longer, 6 to 12 months, sometimes longer. I have some clients whose advanced paroles have been pending about 14 months now. In those cases, it is pretty difficult to get them expedited. People have tried, raising service requests, have tried getting congressional liaison help. Sometimes those are successful. Unfortunately, the only way that we have seen that definitely gets results is federal litigation. And Stephen Brown, the partner in our office who handles federal litigation, has filed a number of these EAD or AP delay cases. I think his general principle is that once it's been pending for at least 6 months is when he feels that he can file a delay case that will have a good chance of success. Typically, I believe from the time he files it, there's about a 60-day turnaround that we usually see results in, although if you are interested in exploring that, you can always contact him and set up a appointment to discuss it in more detail, and he would have more specifics there. But yeah, for an 8-month pending period, that is something that is a potential for litigation.
Balaji has this question from Facebook. His last paycheck is in July, and now he wants to transfer the company from company A to company B. Will he has a problem? Yeah, you may have a problem transferring within the United States. You can do a consular processing where you can go and get the stamping approved in India and come back. But if you try to change from company A to company B and then you don't have a paycheck, and the last paycheck was July, might be an issue. Because the first thing the officers are going to look into is that, is the H1B, are you working for the company? And if so, do you have the pay stubs for that particular company? So they look into that very carefully before they approve the H1B change of employer.
Someone is asking, if an I-140 is denied, can the underlying perm be used for another I-140 application? Yes. So the perm, as long as an I-140 was filed within the initial validity period, which is 6 months from the labor certification, as long as an I-140 was filed during that time, the perm becomes valid sort of indefinitely. So if that first I-140 got denied, even if it's now past the period where the initial 6-month perm validity is passed, you can still use that existing perm to file another I-140 application based on it. You just need to attach a copy of the first I-140 receipt notice to show that action was taken within the initial 6-month period.
MTV Wids as this question. He's an H1B approved EAD. I'm assuming it's a 485 EAD. Can I go outside the country in 5 years and come back and work? Yeah, you can. But the new company has to file a H1B. Can I come back on GC EAD Advanced Parole? I wouldn't recommend that option at all. It is a little bit risky venture what you're trying to do. I would strongly recommend you consult a lawyer before you take any of those decisions.
Kind of related to that previous I-140 question of filing a second I-140 based on the same perm. One thing to keep in mind is that you most likely will not be able to file the second I-140 in premium processing initially. USCIS tends not to accept premium processing when you are filing a second I-140 based on a perm that was already submitted. Their reasoning for that is that they have to go back into their archives to pull the original labor certification document from the first I-140 file. We're not sure why they still need to do that, because we no longer, since the pandemic, we don't need to submit the original perm labor certification anymore. We just submit a copy, but that practice by USCIS is still carried over. And so you probably will not be able to file the second I-140 in premium processing. What we usually do is file it in regular processing. Then when you get the receipt notice, you can start trying to upgrade it. They may not accept the upgrade right away. Sometimes, if they don't accept it, they'll just send it back to you with the check. And then you just wait a couple weeks, try again. We've tried sometimes like 3 or 4 times before they accept it. So yeah, it just depends on how long it takes for them to pull the original file.
Question, can Kamala make the priority dates current? Yeah, not directly, but yeah, she can stop counting the family members. She can give the unused green cards that have been wasted for decades because the USCIS did not work properly. They can use all those simple steps to get the priority date current. If not, at least to get to the 3 to 4 year waiting period, she can do it. But will she do it? I don't know about that. But yeah, she has the capacity to do it if she wants to do it. I'm assuming this is all we are speaking once she becomes the president.
We have a question from Pradeep, who had an H1B, H4, and H4 EAD filed in premium. He got an RFE for the EAD application because the photos weren't included, and wants to know, will the EAD still be processed in premium after they respond to the RFE? I am not sure that they will be. Hopefully they will, but if the H1B and H4 are already approved, I don't know that they will still hold the I-765 to that premium processing time once it's kind of separated from the H1B.
Anything else, Rebecca, that you want to address before we close?
No.
Thank you guys for coming. The next conference call, Zoom call, the next will be every Tuesday. We take live questions. Don't forget that we do have a daily Zoom call where we take live question answers. The link is provided at the bottom. And also, we are going to come up with the pending legislation, what letters need to be written. Most probably, we'll start making our way next week so that by November 1st week, we have already with the pending legislation that we think so are important for you. We think so has a likelihood to pass. We're going to advise you about it in the coming weeks. So please stay tuned to our Tuesday live sessions every week.